Imagine using a product for years, one that has been advertised as safe and even beneficial. Your trust in this product is founded on the reputation of the giant company behind it, serving millions of customers. However, after years of faithful use, you begin to notice peculiar spots appearing on your body. Concerned, you decide to seek medical attention and discover a disheartening truth. You have been diagnosed with serous carcinoma, a form of ovarian cancer. Adding to the distress, you learn that this cancer has been induced by the very product that had been touted as safe. Dean Berg, a physician's assistant in South Dakota and mother of 2 healthy young girls, experienced this exact situation. At the hospital, she received a pamphlet that outlined the risk factors, which she carefully reviewed. No family history of reproductive cancer, no infertility or fertility drug use, no prior cancer, no unhealthy diet or overweight issues. Then she reached the talcum powder section. She checked her Johnson & Johnson body powder and baby powder, both containing talc. In 2007, she went through genetic testing to uncover the truth. The results showed that she didn't possess either of the 2 main mutations that raise the risk of reproductive cancers. 2 years later, her ovarian tissue was examined, and talc was discovered in one of her ovaries. Not long after her cancer went into remission, she chose to take legal action. This marked the first lawsuit against Johnson & Johnson involving their baby powder products to reach a trial. Following her suit, thousands of other cases emerged, nearly all of them women and many black women who Johnson & Johnson had targeted for the baby powder sales. Quietly, the company adopted a strategy to bypass juries entirely. Using a legal maneuver previously employed by Koch Industries Johnson & Johnson, a nearly $500 billion company with a credit rating surpassing that of the United States government, opted for bankruptcy. As a result of this move, the fate of 40,000 ongoing lawsuits, along with the potential for future claims from cancer victims and their families, now lies in the hands of a single bankruptcy judge situated in the company's home state of New Jersey. The employed legal maneuver is known as a Texas Two-Step Bankruptcy. Put simply, a Texas Two-Step Bankruptcy is a legal process that a company can use to pass off its legal and financial liabilities to another company. Just as the name suggests, there are 2 main steps to this legal chicanery. In the first step, the parent company, such as Johnson & Johnson, creates a new corporation in a jurisdiction like Texas, whose system of corporate law is understood to be very business-friendly. In the second step, the company undergoes a reverse merger or divisive merger, which allows multinational corporations to segregate their liabilities from their assets. All of the liabilities and a small percentage of their assets are transferred to the new corporation, while most of the assets, tens of billions of dollars, remain with the old company. When the Texas Two-Step is complete, the newly created company files for bankruptcy. This bankruptcy filing usually occurs in a state where the courts are considered more friendly to corporations such as North Carolina. In practice, this means the injured plaintiffs have no right to a jury trial, and damages for injuries are limited to whatever assets were transferred to the new company from the old corporation. The old corporation, while inconvenienced by the litigation, continues its business uninterrupted. The primary purpose of the Texas Two-Step is for the parent company to evade third-party liabilities, effectively preventing litigants from pursuing those claims against the parent company. Although perfectly legal, the Texas Two-Step raises issues of ethical propriety. Corporate legal departments lobby state legislatures for favorable laws, then use those laws to evade liability. In the talc litigation, Johnson & Johnson never declared bankruptcy. The company that actually went bankrupt was a company called LTL Management. LTL, which stands for Legacy Talc Litigation, was established in Texas on October 11, 2021. 3 days later, on October 14th, LTL Management filed for bankruptcy in Charlotte, North Carolina. The new company assumed all of Johnson & Johnson's talc liabilities, some 40,000 cases. Meanwhile, Johnson & Johnson took tens of billions of dollars in assets without any talc-related claims, leaving it free to carry on its operations as usual. Johnson & Johnson isn't the only company that has used the Texas Two-Step to evade liability. In 2017, Koch Industries used it to protect a subsidiary, Georgia Pacific, from claims concerning asbestos contamination. Since then, other multinational corporations have evaded accountability by dancing the Texas Two-Step. If companies can use the two-step approach to shield themselves from various consumer liabilities, what mechanisms are left to guarantee their accountability and the rights of victims? This is another video in our series looking at legal corruption. If you enjoyed this video and would like to know more, watch our video on profit shifting.